I would like to begin by acknowledging that we meet today on the unceded land of the original people of the nation, and to pay my respects to their elders and families, past and present. I would like to acknowledge too the ongoing existence of their laws and feel the responsibility that this brings to us here at this law school. So good afternoon, everyone, and thank you for joining us in this much needed discussion panel on examining the ICJ advisory opinion of the legality of Israel's occupation of Palestinian territory. My name is Adil Hasan. I'm a senior research fellow with the laureate program in international global corporations and international law, and I'll be chairing this panel. So it's an immense honor and a pleasure to be introducing what is a stellar list of speakers we have with us today. And I'll introduce them in the order they'll be speaking. So first we have Dr. Sophie Rigney, who is senior lecturer in law at RMIT University. Sophie will be speaking on the topic of the right to self-determination. Next, we have Mr. Jamil, who is a PhD scholar at MLS, having previously lectured at the Faculty of Law, Delhi University. Haris will be speaking on the topic of peremptory norm violations and third-party obligations. Next, we have Dr. Dehm, who is an ARC DECA fellow and senior lecturer at Trobe Law School. Julia will be speaking on the topics of natural resource exploitation, permanent sovereignty of natural resources, and reparations. Next, we have Dr. Tzouvala, who is associate professor at the ANU College of Law. Ntina, who's sadly joining us online thanks to the fog, will be speaking on the limits of the occupation framing of this advisory opinion. Last, but certainly not the least, we have Dr. Shahd Hammouri, who is lecturer in law at the University of Kent in the UK and is currently a Kathleen Fitzpatrick visiting fellow with the laureate program. So Shahd will be speaking on the topic of moving forward and picking up this advisory opinion. So at the outset, I wanted to briefly introduce this advisory opinion. The advisory opinion was pronounced on the 19th of July, and in response to the request made by the UN General Assembly through its resolution of the 30th of December 2022. In this resolution, the General Assembly requested the principal judicial organ of the UN to render an authoritative legal opinion on the following two exact statement of legal questions. A, what are the legal consequences arising from the ongoing violation by Israel of the right of the Palestinian people to self-determination from its prolonged occupation, settlement, and annexation of the Palestinian territory occupied since 1967? Including measures aimed at altering the demographic composition, character, and status of the Holy City of Jerusalem, and adoption of related discriminatory legislations and measures. The second question is, how do these policies and practice affect the legal status of the occupation, and what are the legal consequences that arise for all states and the United Nations from this status? So back in February, some of us must have watched it online. This year, the court held public hearings in which 49 member states and 3 international organizations presented oral statements to the court with the aim of furnishing it with information on the questions submitted to the court. So with near unanimity, the court found that it had jurisdiction to give the advisory opinion requested, that it is of the opinion that the state of Israel's continued presence in the occupied Palestinian territory is unlawful. And this, I note, goes beyond the previous international legal determinations over the past several decades regarding the specific Israeli actions in occupied Palestinian territory being determined to be legal. And this includes the Wall advisory opinion from 2004. But by pronouncing here on the illegality of the entire occupation regime itself. Next, that it is of the opinion that the state of Israel is under an obligation to bring to an end its unlawful presence in the occupied Palestinian territory as rapidly as possible. That it is of the opinion that the state of Israel is under an obligation to cease immediately all new settlement activities and to evacuate all settlers from the occupied Palestinian territory. That it is of the opinion that the state of Israel has the obligation to make a reparation for the damage caused to all natural or legal persons concerned in the occupied Palestinian territory. that it is of the opinion that all states are under an obligation not to recognize as legal the situation arising from the unlawful presence of the state of Israel in the occupied Palestinian territory, and not to render aid or assistance in maintaining the situation created by the continued presence of the state of Israel in the occupied Palestinian territory. And by doing so, as Haris will elaborate on, the court has explicitly refused a framing of this simply as a bilateral dispute. And finally, that it is of the opinion that the UN and especially the General Assembly and the Security Council should consider the precise modalities and further actions required to bring to an end as rapidly as possible the unlawful presence of the state of Israel in these territories. On the last point, it is instructive to compare the General Assembly Resolution 73-295 adopted in May 2019 in the wake of the advisory opinion delivered by the ICJ on the Chagos Island question, in which the court was of the opinion that the United Kingdom was under an obligation to bring to an end its administration of the Chagos archipelago as rapidly as possible, and that all member states are under an obligation to cooperate with the United Nations in order to complete the decolonization of Mauritius. This General Assembly resolution demanded that the UK unconditionally withdraw its colonial administration from the area within 6 months. Also, given the court's opinion that Israel's discriminatory legislation and measures in the occupied Palestinian territory constitute a breach of Article 3 of CERD, which condemns and calls upon states to prevent, prohibit, and eradicate practices of racial segregation and apartheid, the UN General Assembly resolution from November 1974, which suspended South Africa from the UN on account of its adoption of the policy of apartheid, a suspension which was only lifted in 1994 when South Africa transitioned to an actual democracy for all and away from the status of an international pariah state. This offers another practical modality for the General Assembly to formulate a response to these determinations by the ICJ. Also noteworthy is the declaration attached to the advisory opinion by the Australian judge, Hilary Charlesworth, formerly of this parish, in which she has provided detailed reasoning regarding the discriminatory effects of Israel's measures on women and children, as well as regarding the legality of Israel's effective control of occupied Palestinian territory, including the lack of any legal basis for its threat or use of force as an occupying power, as against the existence of a legal basis under customary international law for the exercise of resistance by populations under occupation and against the occupying power. The final point I'll make concerns the widely prevalent confusion in the public discourse over whether the ICJ advisory opinions are binding or not in their entirety. And here I find instructive to quote the Palestinian international legal scholar, Professor R.D. Emsis, who has observed that, and I quote, while technically advisory opinions are on their face non-binding, to the extent that the principal judicial organ of the United Nations, being the ICJ, makes an authoritative determination on how to determine the relevant international legal principles, which are of themselves already legally binding because they form a part of customary international law, those aspects of the rulings are binding. Now, without further ado, I wanted to invite Dr. Rigney to share with us.
So thank you, Adil, and as always, thank you for creating this space with such generosity. And thank you to all of you for being here. So in this advisory opinion, self-determination is the key territory of contestation and determination. The General Assembly, as we've already heard, phrased the request as, what are the legal consequences arising from the ongoing violation by Israel of the right of the Palestinian people to self-determination? So it's therefore self-determination that is the overarching right and legal claim from which then the question of particular state practices by Israel are examined. The opinion, after addressing jurisdictional and procedural points, commences its section on the general context of the situation of Israel in the occupied Palestinian territory, with the placement by the League of Nations of Palestine as a Class A mandate under Great Britain as the mandatory power. From this starting place, the ICJ does not stretch its gaze back to the Balfour Declaration or earlier, and does not engage with the fact that under the San Remo resolution, which vested Palestine with Great Britain as the mandatory, Great Britain was expressly responsible for putting into effect the Balfour Declaration. Thus, it was the League itself that empowered Great Britain to bolster Zionist claims to Palestinian territory. Whilst the 1971 ICJ Namibia advisory opinion makes clear that the mandate system had an ultimate objective of the self-determination and independence of the peoples concerned, this was by no means guaranteed. In 1919, Balfour himself wrote that, in the case of Palestine, we deliberately and rightly declined to accept the principle of self-determination. So progressing from the League as a starting point is therefore only a very partial history, but it can be instructive for us as we consider self-determination as a right and its particular contours and challenges and the place of self-determination in this particular advisory opinion. Because it was at the League that semi-peripheral actors, to use Arnold Becker-Lorca's words, worked to remove international legal obstacles to sovereignty, in particular the standard of civilization. And in so doing, semi-peripherals made possible the emergence of a right to self-determination. So it was then this vernacular of self-determination that many peoples grasped onto to frame their justice claims, both at the League and in the decades since. But as Lorca points out, while self-determination was an argumentative strategy, it was the standard of statehood, conceptualised as government, people and territory, that became the established law. This ultimately allowed some peoples to demand or obtain by force territorial control and thus to acquire self-determination. But this, of course, excluded those who could not make the same claims to territorial control and therefore statehood, particularly Indigenous peoples from settler colonies, who used the argumentative strategy of self-determination at the League, but were rebuked. Self-determination was developed in ways that would strengthen states' claims to territory rather than any Indigenous justice claims. The concept of self-determination at the League thus remained deceptively imperial and conservative, as per Adam Getachew, and was repurposed to support racial hierarchies. Self-determination in mandated territory like Palestine became not self-determination in any European sense, but instead a minimalist regime of consent and consultation. Ultimately, self-determination was appropriated at the League in ways that were aimed at warding off its radical implications. So this is useful background as we consider self-determination in this opinion. This opinion does not ground self-determination in the League, but rather in the UN Charter and the huge number of international legal documents that prioritise self-determination. It notes that in cases such as this one, cases of foreign occupation, the right to self-determination is a peremptory norm of international law. This is the first time the court has declared self-determination to be a peremptory norm, albeit apparently limited to cases of foreign occupation. This determination, against a background of historical hesitancy to refer to peremptory norms by this court, both generally and specifically in relation to self-determination, is significance. And indeed, this significance cannot be overstated in the separate opinion of Judge Twabi's words. The court found that there were 4 elements relating to self-determination which are of particular relevance in these proceedings. These are, first, the right to territorial integrity as a corollary of the right to self-determination. Second, that self-determination is a protective force against aims aimed at dispersing the population and undermining its integrity as a people. Third, that self-determination involves the right to exercise permanent sovereignty over natural resources. And fourth, that a key element of the right to self-determination is the right of a people to freely determine its political status and to pursue its economic, social and cultural development. The first 3 of these 4 relate to the relationship between people and territory. Powerfully, the court held that Israel, as the occupying power, has the obligation not to impede the Palestinian people from exercising its right to self-determination, including its right to an independent and sovereign state over the entirety of the occupied Palestinian territory. The court noted that Israel's annexation of large parts of the occupied Palestinian territory violates the integrity of that territory as an essential element of the Palestinian people's right to self-determination. Yet here is where some ambivalence or uncertainty comes in for me. While bolstering Palestinian self-determination on the basis of territorial integrity may be a powerful move here, simultaneously strengthening both self-determination and also territorial and statehood claims for Palestinian people, part of me holds a disquiet at what this means for groups without continuous territorial claims. At the League, self-determination was malleable enough to be invoked in justice claims, yet still support the imperial order. And that is what I am reminded of here. Today, we know that self-determination for Indigenous peoples has been limited under the UNDRIP to claims within existing territorial states, that minimalist self-determination is instead based on consultation, which is itself very minimalist. So while I'm relieved to see a reiteration of both self-determination and of territory in this case and of their concomitant nature, I'm also concerned at what such reiteration might mean for self-determination within an international law which continues to be imperial and concerned primarily with states. For as Umaduzu, Adil, and others have written, self-determination can be used to reinforce state structures as well as in support of secessionist and revolutionary struggles. And there is a real question as to whether self-determination sanctions or subverts the international state system. In this case, we see this malleability of self-determination in the diversity of views expressed in the separate opinions. Yet despite sometimes radically different approaches taken by the judges, and we can talk about that in questions if we like, in all cases, there's an overwhelming link between self-determination and statehood. Briefly, the fourth element of self-determination frames self-determination as a right itself that's also a precondition to the exercise of other political, economic, social, and cultural rights. The court was of the view that Israel's policies and practices obscure this. So ultimately, taking the four elements of self-determination together, the court decided that the prolonged character of Israel's unlawful policies and practices aggravates their violation of the right of the Palestinian people to self-determination. Israel's unlawful policies and practices are in breach of Israel's obligation to respect the right of the Palestinian people to self-determination. So to end, I want to return to the role of law in stating a norm and what this may or may not make possible. In particular, returning to the significance of naming self-determination as a peremptory norm, Judge Gomez-Robledo's words are worth pausing on. But in doing this, the court gives the primacy of the right to self-determination its full import and weight in the hierarchy of the fundamental rights and duties that structure the contemporary international order. This is of prime importance and should be recalled at all times, in all places, to all people. The court also confers on the right of peoples to self-determination its full axiological nature as a concept that reflects and at the same time inspires a worldview. So what is this worldview? We'll each have a sense of what self-determination means in Palestine, and I invite you each to reflect on this now. I'll offer my own somewhat limited thoughts. Overnight, the London Review of International Law released a special publication on international law in Gaza. My short contribution particularly is international criminal law, but the opening passage is just as relevant for questions of self-determination. So I want to end here on this imagining of Palestinian self-determination, this world building. So I've written, what does it mean to imagine a future where Palestine is free, where babies are not hungry and where their bodies are safe, where poets can live and write into old age, not words foretelling their deaths, but singing of their lives, where fishermen can catch bountiful nets of fish and the olive trees are full and the bakeries have flour, where there is peace, prosperity, care and nurturement. What does it mean to imagine this, and can international law bring us to that future place?
Thank you, Adil, for organizing this panel discussion on the significant advisory opinion and for inviting me to be part of this panel alongside such amazing friends, colleagues, and colleagues. Adil has asked me to share my views on the issue of erga obligation, which I think is a crucial part of the advisory opinion, with consequences not just for Israel but also other states and the United Nations, which Adil briefly referred to in his introduction. Though there are several important threads to this, I want to focus on three important aspects of advisory opinion on erga omnes obligation. The first is to situate the nature of erga omnes obligation, that is, obligations of a state towards all members of the international community, vis-a-vis arguments about bilateralism. Now, in this regard, I want to pay attention to the nature of the court's position on this and what it evokes. So a good place to begin is to draw your attention to the argument made by some states before the ICJ, and these states were Israel, United States, and the United Kingdom, that the question posed before it was a bilateral issue, and that only a negotiated solution can resolve it. Now, in response, ICJ rejected the argument that Israel's policies and practices in occupied Palestinian territory comes within the realm of bilateralism, and stated that because Israel's actions violate certain obligations erga omnes, the matter needs to be decided within the realm of universalism. Now, among other things, the court said that Israel has violated and continues to violate the rights of Palestinian people to self-determination, which is a norm of jus cogens, or in other words, a norm from which no derogation is permissible. So as per the court, the obligation to respect the right to self-determination is not a bilateral matter that is open to negotiations, but rather this obligation is universal in character. Now here I want to emphasize that this kind of universalist argument has a very specific history. And this is not the first time that it has been used against a colonial power like Israel. Rather, the history of the authorship of this form of universalism, which demands non-derogation from the right to self-determination, has its roots in third world internationalism of the decolonization era. Both these concepts, self-determination and jus cogens, were shaped and mobilized by the third world during that period. Self-determination was a key tool in the arsenal of the third world to demand independence from colonial rule in Africa and Asia and assert their right to permanent sovereignty of natural resources. Likewise, the concept of jus cogens was central to the claims of non-aligned and socialist states in the decolonization period. Egyptian international lawyer George Abisa described the inclusion of jus cogens in the Vienna Convention on Law of the Treaties as the greatest triumph for the non-aligned states. So in the present case, I think there was a reenactment of the third world internationalism of the decolonization period, which sought to envision a post-imperialist world by embracing international law. Now, notwithstanding the limitations of such a universalistic project, there is an important normative message that is embedded in it. That is, fight against imperialism demands a collective response. That people's right to self-determination is non-negotiable and non-derogable, and that domesticating it or making it a bilateral issue loses sight of the underlying structures of imperialism and racism. Now, therefore, it was not surprising to me to find out that three states that argued before the ICJ that the question of Palestine is a bilateral question are the same three states that objected to the inclusion of self-determination as an example of jus cogens in an International Law Commission's report in 2022. And these states were, and I think it is important to rename them, United States, United Kingdom, and Israel. By making it clear that Israel's actions are violative of the jus cogens right to self-determination, one of the effects of ICJ's opinion will be that no negotiation, bilateral or otherwise, can put conditions on the right of Palestinian people to self-determination. In other words, what the ICJ has made clear is that the end of Israel's illegal occupation of Palestinian territory is not open for negotiation. Building on this, the second point from the ICJ's advisory opinion that I want to highlight concerns the obligations of third states. This includes the obligation not to recognize or contribute to Israel's action in relation to the occupied Palestinian territory. Now, this fundamentally means that the relationship of other states with Israel must be based on a distinction between Israeli territory and the occupied Palestinian territory. And if Israel acts on behalf of occupied Palestinian territory, other states are under an obligation to abstain from such dealings, be it any form of diplomatic or treaty relations or trade relations. The ICJ also stated that both the United Nations General Assembly and the Security Council should take precise steps to end Israel's unlawful occupation as rapidly as possible. Now, in legal terms, this has significant implications for third states and can be mobilized to demand actions from them. And I think we are already seeing the effects of this opinion. For instance, after the advisory opinion, the Australian Centre for International Justice came out with a non-exhaustive list of measures and called on the Australian government to implement them. These measures demand, among other things, targeted sanctions, imposition of an arms embargo, refraining from entering into any free trade agreement with Israel, and providing clear advice and direction to institutions such as universities to not engage in commercial or non-commercial relations with Israel. As the director of the center, Rawan Arraf, stated, this is not a wish list, but rather part of Australia's international legal obligation. This brings me to the third point that I wanted to make. So, though this advisory opinion is being described as a landmark moment in the struggle for free Palestine, ICJ's findings that Israel has violated right to self-determination, that the Israeli occupation of the Palestinian territory is illegal, and that Israel's action violates norms of international humanitarian law and human rights are not novel, or as Tzouvala in his declaration said, ICJ's findings are not surprising or earth-shattering. We all knew about it. I want to emphasize that Palestinian people, lawyers, activists, academics, and Palestine solidarity movements have for years called out Israel for its oppressive activities and have initiated calls for boycott, divestment, and sanctions. And I think it is important to remember that the advisory opinion is not the end to the demand and struggle for free Palestine. This opinion is undoubtedly a tactical legal victory in the larger political struggle for a free Palestine. It is not an end in itself. So in a way, it also exposes the limits of liberal international law insofar as it leaves us at the mercy of powerful states and global capitalist structures in responding to the persistent question of Palestine. So beyond such liberal status responses, the Palestine solidarity movements have shown that there are different ways of prefiguring, imagining, and enacting a new world, which need not remain trapped within the structures set by dominant power relations. And I would like to end by referring to one such example from India, where in February 2024, a port workers union called the Water Transport Workers Federation, which represents 14,000 port workers in India, issued a declaration refusing to handle weapons destined for Israel and called upon the workers of the world and peace-loving people to stand with the demand for free Palestine.
Thank you so much to Adil and everyone who's made this event possible. I briefly want to touch on two aspects of the advisory opinion decision, the discussion on natural resources and the discussion of reparations. And these are not abstract legal questions. Water is, as the former Special Rapporteur on the situation of human rights in the occupied Palestinian Territory, Mark Link, wrote in his 2019 report, and I quote, an indispensable precondition for life, a vital public good, an economic cornerstone, a finite resource, and a necessary crucible for ensuring human dignity. Access to agricultural land is about the ability of a peoples to feed and sustain themselves, but also, especially olive trees, are a powerful symbol of Palestinian culture, connection, steadfastness, and resistance. As we bear witness to the live-stream genocide in Gaza, the deep implications between ecocide and genocide are impossible not to see. The devastation of farmland, half the territory is trees razed, soil and groundwater contaminated by new munitions and toxins, sea choked with sewage and waste, air polluted by smoke and particle matter, all reflect a systemic and deliberate inflection on Palestinians of conditions of life calculated to bring about the physical destruction of the group in whole or part. Resources are thus not just economic inputs, although they are also crucially that, but are about the material conditions of our world and how it is made habitable or unlivable. Reparations, on the other hand, are or must be, as Othemi Tawa has written, a construction project. They call on us to contend with the immense injustice and ask how it might be possible to remake the world otherwise. That is, they are a project of world making. So turning to the court and the advisory opinion, the court highlighted that permanent sovereignty over natural resources is both a principle of customary international law and one of the four elements of self-determination, as has been introduced by Sophie. This principle was first articulated in the early 1950s and was a key demand of third world decolonisation movements, as well as a central element of a proposal for the new international economic order in the 1970s. The ICJ previously touched on permanent sovereignty of natural resources in the context of occupation in the 2005 armed activities on the territory of the Congo, but did not find it breached on the facts in that case. In this advisory opinion, however, the court held that, and I quote, in depriving the Palestinian people of its enjoyment of the natural resources in the occupied Palestinian territory for decades, Israel has impeded the exercise of its right to self-determination. The court has most of its factual discussion of how Israel has been exploiting the natural resources in the occupied Palestinian territory for its own benefit and for the benefit of settlements as part of its discussion of the broader legality of the settlement policy. In that section of the judgment, the court treated exploitation of natural resources as one of the key aspects of the illegality of the settlement policy, along with transfer of civilian population, confiscation or requisitioning of land, extension of Israeli law, forced displacement of the Palestinian population, and violence against Palestinians. In this section, the court refers to Article 55 of the Hague Regulations, which states that an occupant shall be regarded only as the administrator and usufructuary of the natural resources and must safeguard the capital. The Fourth Geneva Convention, which states that the occupying power's duty to ensure the local population has an adequate supply of foodstuffs, including water. And Principle 23 of the Rio Declaration, that the environment and natural resources of people under oppression, domination, and occupation shall be protected. The ICJ particularly focused on water rights, highlighting how water supply to settlements was prioritised and the way Palestinians are prevented from accessing groundwater or the water in the Jordan River. Control over water has been central to the occupation since the beginning. 2 military orders in 1967 transferred authority over all water resources in the occupied territory to the Israeli military and prohibited Palestinians from constructing new or maintaining existing water installations without a military permit. The ICJ also identified how water and land policies had reduced Palestinian agricultural land by more than half between 1980 and 2010, decimating the agricultural sector, which in 1972 contributed to 35% of GDP to less than 4% now. The court also notes extraction of minerals in the Jordan Valley and the Dead Sea, as well as quarrying in Area C of the West Bank. However, I think the economic significance of these industries is not completely foregrounded by the court. Michael Link documents in his report how quarrying has increased substantially in recent years, reaching 17 million tonnes in 2015, that 94% of this quarrying produce is shipped to Israel for construction and infrastructure purposes, and 20 to 30% of Israel's annual quarrying requirements come from the West Bank, even though royalties for this extraction are paid to Israel. A 2012 study by Al-Haq found that there are approximately 50 Israeli cosmetic factories operating in the Dead Sea, extracting mud and other resources for domestic and export markets. Gas and oil resources are not mentioned by the ICJ, yet in the Mediterranean Sea off the coast of Gaza and Israel lie substantial oil, gas and shale oil deposits. Since 2016, Israel has been auctioning off these blocks to international oil and gas corporations. In October last year, amidst the genocide, the Israeli Energy Ministry announced that 12 licenses were awarded to 6 companies, including British multinational oil and gas firm BP and Italian energy giant Eni, to explore and exploit gas fields. So disappearing in the background of the analysis is the role of the corporate actors. Mercury, the Israeli National Water Company, is mentioned, but others that have profited from the exploitation of resources evade attention. But the findings of the ICJ are clear, and I quote, Israel's policy of exploitation of natural resources in the occupied Palestinian territory is inconsistent with its obligations to respect the Palestinian people's right to permanent sovereignty over natural resources. Those companies complicit in and profiting from this international wrongful act are now also on notice. Turning to the question of reparations. The reparations aspect of this advisory opinion was perhaps the most unexpected or surprising part of the decision for many commentators. But that said, the court did not depart from well-established principles of state responsibility, namely that a state who is responsible for an internationally wrongful act has to put an end to that act, namely that Israel must cease all settlement activity and repeal all legislation and measures that are creating or maintaining the unlawful situation. Reiterating well-established principles, the court affirmed that Israel is also under an obligation to provide full reparation for the damage caused by its internationally wrongful acts to all natural and legal people concerns. And this includes obligations of restitution, namely to return land, immovable property and assets seized since 1967, including cultural property, documents and archives. A key part of restitution, the court specified, is also the evacuation of all settlers from existing settlements and dismantling parts of the walls situated in the occupied Palestinian territory and allowing Palestinians displaced since the occupation to return to their original place of residence. And this opens up really important discussions about the right to return of Palestinian refugees displaced during the 1967 Nakba, approximately 245,000 who fled from West Bank and Gaza into Jordan and 11,000 who fled into Egypt. Where such restitution is materially impossible, the court held Israel has an obligation to compensate all natural and legal persons who have suffered any form of material damage due to wrongful acts under the occupation. And I think these statements are really huge. And they open up a whole bunch of really complex discussions about how reparations regime could be designed to support the Palestinian right to self-determination, to rebuild a sustainable economic basis for genuine and equitable human development. However, I think it's worth just noting some limitations too, that these requirements for compensation only relate to wrongful acts post-1967 and thus exclude reparations for those displaced and dispossessed during the 1948 Nakba. Moreover, more than half of the 1967 refugees were already refugees from 48 and thus would probably be entitled to very limited restitution for the second dispossession, given they'd already been dispossessed of their land and home 2 decades earlier. It's also interesting to note that the reparations provisions focus only on Israeli obligations, whereas following on Harris's presentation, we might also want to think about the obligations that other states who have enabled and supported the illegal occupation, or those corporations who profited from it, and the exploitation of natural resources in the occupied Palestinian territories might also owe.
Yes.
Yeah.
Okay, all right. Thank you for your patience. I was planning and I was really keen to be there. Qantas had different views. So I am joining from the unceded lands of the Nawago and Gambri people, and I want to pay my respect to their elders, past, present, and to come. And I want to thank Dr. Adil Hasan Khan for his very kind invitation and for asking me to join this very important panel. So, as others have said already, this is a very important decision. And I think it's an important decision insofar as it confirms and gives institutional backing and authority to factual assertions and legal arguments that Palestinians have been making for decades. The court, as you heard also from Dr. Dehm, engaged seriously with the material conditions on the ground, including city and road planning, the everyday control of Palestinians' movements, the operation of police and paramilitary violence, the control of water, the extraction of resources, the regulation, or rather I should say strangulation of trade relations, and concluded that the way that Israel conducts these occupation violates Palestinians' right to self-determination. In relationship to self-determination in particular, the court drew heavily from what I will call the law decolonization, as developed in the 1960s and 70s, primarily by the UN General Assembly, and it also drew from its own jurisprudence on self-determination to identify the contours of the right and its modes of violation. Others, including Julia and Sophie, have spoken eloquently about the different aspects of the right. What interests me here in particular is the court's insistence on the integrity of the occupied Palestinian territory. In paragraph 78, the court clarified that unless there were specific reasons to do otherwise, it would refer to the OPT as a single territorial unit, the unity, contiguity, and integrity of which are to be preserved and respected. And this was a quote. This general outlook led to concrete legal findings in paragraphs 237 through to 239, where the court found that Israel's governance of the occupied Palestinian territory is in violation of the Palestinian right to self-determination in at least 2 ways. First, as Sophie said, by the fragmentation of the territorial unit of self-determination, and secondly, by the fragmentation of the people who are the bearers of the right. In so doing, the court drew from its own jurisprudence, especially the Chagos Islands advisory opinion, that determined partition to be a violation of the right to self-determination. In turn, that pronouncement was grounded heavily on paragraph 6 of Resolution 1514, in which the General Assembly adopted an even bolder and broader frame. Paragraph 6 read, quote, any attempt aimed at the partial or total disruption of the national unity and the territorial integrity of the country is incompatible with the purposes and principles of the Charter of the United Nations. In this respect, this recent advisory opinion can be read as a concretization of the international law of decolonization, as articulated in the multiple UN General Assembly resolutions that I alluded to above. It was against this law of decolonization that Israel's occupation was measured and found to be unlawful. Notably, this was against the opinions that had been expressed for decades by many leading international lawyers, including, for example, the outgoing holder of the discipline's most prestigious chair in international law, that occupations cannot be lawful or unlawful because they're simply a factual situation that triggers the application of particular aspects of IHL. In so doing, so in defying these legal arguments, the court also affirmed, in my view, the ongoing real-world and also doctrinal relevance of the international law of decolonization. This is good news, at least for those of us who think that the international law of decolonization was some improvement in international law. But for those of you who know me, I'm not in the habit of only delivering good news. The bad news, in my view, is that the question posed to the ICJ, and by consequence, the answer given by it, was a question that at the very least took for granted what the ICJ then went on to pronounce unlawful, namely partition as a method of governing colonialism and decolonization. This is because the advisory opinion takes for granted that the unit of self-determination is the occupied Palestinian territory, and that the people who bear the right are Palestinians who reside in the OPT. What becomes invisible, or we could go perhaps as far as saying as indirectly ratified in this process, is the initial act of partitioning Palestine. Indeed, the ICJ cited repeatedly, although not necessarily approvingly, even though not disapprovingly either, UN General Assembly Resolution 181 of 1947, which infamously purported to partition the Palestine Mandate between a Jewish and an Arab state without any input from the local population. Here, I will not focus on the concerns of Palestinians about the percentages and quality of land allocated to each state. Rather, I want to flag that partition itself, especially absent an authorizing referendum, and given the staunch opposition of the representatives of the territory's overwhelming majority at the time, would have been undeniably unlawful based on this law of decolonization, as developed 20 years later. In fact, some Palestinian legal scholars, such as Adil, argue that it was unlawful, even judged against the legal standards of the late 1940s, including legal duties flowing from the status of Palestine as specifically a Class A mandate. Given this convergence, though, be it as it may, the PLO famously resisted this partition framing until its historic compromise in 1988, when it accepted the fact of the partition as baselines for its negotiation with Israel. Given this convergence between the UN General Assembly and, more importantly, the states that are its members and the PLO itself, it would have been improper for the court to approach the question in any other way than the way that it did. However, it does strike me that even as we celebrate the court's important findings and rulings, we ought to think of contemporary international law, both as a vehicle for decolonization, but also as a technology of partition itself, as a technology that in its contemporary iteration takes for granted the so-called two-state solution, even though such an approach is blatantly unlawful under the international law of decolonization, and as a technology that fragments both Palestine as a political unit and Palestinians as a people. Palestinians who reside then in the OPT, according to international law, become the bearers of the right to self-determination, while the 1.8 million Palestinians residing within the state of Israel become a minority that enjoys quote unquote ordinary civil and political rights and perhaps some minority rights. And finally, diasporic Palestinians who are refugees become refugees or citizens of their respective host states. This is precisely the separation and dispersal that the ICJ find to be unlawful. This critique does not imply that the court should or could have decided the case differently. I do think, though, that taking seriously the prohibition of partition compels us to think about the limits of the questions posed to the court, but also to take seriously the limitations of the prevailing legal framing of Palestine in international law. And this is exactly why I think of Palestine as a litmus test for the international legal order and for all of us international lawyers. I take it as a litmus test because it reveals the power and the limitations of the rules that we inherit and the power and limitations of how we choose to deploy them. Thank you very much.
So thank you for that, and thank you, Adil, for the invitation. Again, I feel honored to be among friends and comrades, and a lot of the comments that have been made so far touch a lot on the thoughts that I have in mind. So to start with, the relevant reality that we are talking about now has reached an unprecedented level of horror. As we speak now, it has become a very normal scene to find parents with headless children or body fragments. And it's very important to keep in mind the urgency of the words that we're using as well as the relevant reality. My second contextual note is that I actually watched this judgment pronunciation with my mother. And my mother was born in 1967, and my grandmother fled on her feet in 1967. So it was quite emotional to observe it, and quite emotional that it took all the way till I reached to become a doctor of international law until this very obvious words were being said. And of course, my mother at multiple intervals was like, "Is this where you guys are still at?" And of course I was clapping because clapping, crying and screaming at what is being proclaimed. And what I tried to explain to her is this is dispelling a lot of the bad faith myths that were tolerated by liberal lawyers for so long, and a lot of the, excuse my language, bullshit that we had to deal with. So first of all, historically and presently, Palestinians were coerced to negotiate the illegal. And here I'm referencing Oslo, but I'm referencing a lot of the so-called peace negotiations. The court, and here I'm quoting, and noted that it observes that in interpreting the Oslo Accords, it is necessary to take into account Article 47 of the Fourth Geneva Convention, which provides that the protected population shall not be deprived of the benefits of the convention by any agreement concluded by the authorities of the occupied territories and the occupying power. For decades, Palestinians have been forced to forego that, and the Oslo Accords are a primary example of that. And the ongoing negotiations between Hamas and Israel are an example of that. What Israel is trying to do is to coerce the Palestinians into accepting the illegal again and again. And with this morning's news of propositions about who gets to administer Palestine in the future being US and Arab state administered, which again is ridiculous that the debate is still on that level. But for the Palestinians, proclaiming that Oslo is dead is for us revolutionary. That moment of despair that has led to so much poetry and feeling of being left by the world is once again not historically relevant. And I believe that we need to proclaim the death of Oslo now very strongly. And of course, I'm happy to speak about this later, but the move by the UK to contest the ICC's jurisdiction actually provided a great opportunity for lawyers to blow the last beatings of death to Oslo through the submissions that we saw with John Quigley's being published yesterday. So secondly, Israel's security concerns do not justify aggression against the Palestinians. And this is a very important note. In paragraph 205, it says that the protection of illegal settlers is not a valid security concerns and any security concerns cannot override international law. In paragraph 254, it says Israel's security concerns cannot override the principle of the prohibition of the acquisition by territory by force. That was followed by Judge Tladi's declaration, where he noted the dangerousness of such arguments. And very notably, he said that often when security concerns arguments are made, it's only as if Israel has security concerns, and somehow Israel's security concerns override that of Palestinians. And it's dangerous to note that international media still does that. And not only that, state members are very happy to justify their foreign policy on the premises of Israel's security concerns. Not only that, it's a sobering reminder that security arrangements such as the NATO were also used to override state obligations. And we've noticed that, for example, with the Netherlands, which said that it still needs to supply F-35 components to the NATO pool and doesn't practice influence over that pool because, again, we need to protect so-called security concerns, overlooking that the NATO agreement itself says that we need to respect international law. So this is very important for those of us who have been trying to negotiate this newly found Israeli and US security-based interpretation of international law. Thirdly, declaring the illegality of the occupation casts a red alert on the engagement of the terrorist framework in the context of settler colonization. And this really puts back to the fora that we need to have a serious conversation about the Palestinian right of resistance. It cannot be logically expected that people live for 57 years since 67, but also 48 and also the Great Revolution of 1938. So we're talking about almost over 120 years now, 100 years now of struggle. And here, notably, I refer to the declaration of Judge Charlesworth, which noted that under customary law, the population in the occupied Palestinian territory does not owe allegiance to the occupying power, and that it's not precluded from using force in accordance with international law to resist the occupation. The fact that the population in the occupied Palestinian territories resorts to force to resist the occupation does not itself justify the maintenance by Israel of its occupation. And of course, the Palestinian right to resist existed in ample evidence in international law, countless UN General Assembly resolutions, the first additional protocol where wars of national liberation was a hard-won fight that was pioneered by George Abisab, as well as other references across history. And for us to deny the existence of that right it has never been acceptable, but now it's a more important to open that taboo that has been rendered even cognitively and intellectually a taboo, even for international lawyers to exist in, and it's quite sad. And this, again, taking it to the future means that media corporations need to take this into considerations, as well as states in their justification of foreign policy. I promised to speak of the day after, and perhaps the most important move in the day after. We look at very big declarations by the court, but we're very sure that Israel is going to throw this in the trash as the same as it has ever done. Israel doesn't self-conceptualize that it is doing something wrong, and a good part of the Israeli population do not conceptualize that they're doing something wrong. And as the decision makes it very clear, Israel has for decades denied its international legal obligations. We don't expect this to change. What we expect is that we will have to engage with an international change and for third states to practice their own influence to end this. So when we think about how do we take that forward, we need to be very clear that when we talk about an illegal occupation, we're talking about something a grave illegality of international law that's systematic, structural, and prolonged. It is deeply entrenched within the Israeli war economy, and the only way to stop it is to make that war economy unviable. And that doesn't mean only looking at the investments that have to do with the occupied Palestinian territories. That means Israeli war machine and what funds it. So to respond to the structural nature of the illegality, we need to also think of state responsibility in the same structural manner. So state obligation not to cooperate and not to recognize then would start with asking the question, after transparency, asking the question of what influence does a particular state or corporation practice in the supply chain feeding into the Israeli war economy? And that's the only way forward. One clear outcome of this rationale is that is of course in relation to arms embargoes. Obligations of states here go well beyond Article 6 of the Arms Trade Treaty to include a three-way embargo: no selling, no buying, no transiting of Israeli weapons. And the enforcement, of course, in this case starts with transparency, which unfortunately we haven't seen from the Australian government that still refuses to disclose how much weapons licenses are there. Another outcome, of course, is jet fuel embargo called for by the global energy embargo for Palestine. And that is very important to understand. Now we're looking towards stopping the transit of jet fuel that goes into Israeli warplanes that are dropping bombs on Gaza. And as dictated by the court, we need to be looking for UN General Assembly resolutions to also take this forward. What we see is very big diplomatic reluctance, especially by the Palestinian Authority at the moment. And but this needs to also, again, be something that is taken forward not just by state members, but by civil society actors, political movements, and pressure on all sides. What the court's decision offers us is language that we can use to legitimize and otherwise demythologize arguments usually put forth by liberal lawyers as well as far right-wing lawyers who sought to kind of to cast a shadow on the possibility or not possibility of this. This gives us tools to use international law for our gain, but again, as noted by my comrades here, this is just one step and one drop in the ocean, and this is just the start. When we talk about moving forward, exactly as Dina said, we need to take the conversation into 48, and we need to understand what this has meant. Again, as we watch this, my mother was of, oh, so this doesn't, they said the right of return, Habibti, does this mean right of return? And I had to go through the ridiculous thing of answering to people in Palestinians in Jordan, well, we have to differentiate who was displaced in 67, who of your ancestors by now, my grandma has long gone, and those in 48. It is important to note that the right to return has been one of the conditions of the establishment of the State of Israel, and a condition that it has never responded to. Another thing that we're looking towards is to contest Israel's legitimacy as a member of the United Nations, as well as consistent with its consistent policy to commit crimes against international peace and security. policy. And of course, we only have the example of this morning where it bombed Beirut, calling upon our own collective trauma of the civil war, where Israel, of course, was the primary proxy actor, and its existence that has caused bloodshed for not just Palestinians, but Syrians and Lebanese alike as well, and Egyptians, of course. I realize I ran out of time. Ways forward would be would start with concrete efforts by lobbying states and looking beyond, looking at what the Palestinian civil society is currently advising as the priorities. But taking this forward, this is again a call for questioning the cognitive limitations within the liberal international legal mind that has facilitated us reaching this point where it has reached a settler colonial entity to have a live stream genocide at a moment where we couldn't do anything to stop it for 10 months and over 75 years of illegal settler colonization. So it's a very sobering moment for us to sit and reflect. So thank you.
Mindful of the fact that we have a class in this room, so it's unfortunate that we had 1 hour, but we had a lot of questions set up, and I'm sure there was a lot of questions in the room. But just please join me in thanking our speakers and for this wonderful panel. I also wanted to thank Ela and Professor Margaret Young and Angela in particular for helping us organize this panel, and for Michael for making the online possible. I'm sorry, I'm sure a lot of people have questions, but yeah, we will maybe collect the questions and share it with the speakers, because with the class, I can't stand that door opening, not saying anymore, but thank you.